issued orders. We came before you and the orders were extended by consent. During the existence of those court orders, my lord, the first defendant chose in blatant disobedience of court orders to invade the premises, evict the plaintiff, and create a new status quo. My lord, when we appeared before your sister on 25th, the first defendant, through its counsel, informed that he was not aware that there was invasion. This court sent the deputy registrar, who confirmed blatant disobedience of court orders. And that has remained as much. My lord, it is true, the defendant has an application pending, but that is not a reason for them to disobey. Indeed, my lord, we have an application pending for contempt. And the practice of this court is clear. A party who is in contempt of court orders cannot be heard. If, my lord, the first defendant want to be heard, it must comply first, and then it come before this court to argue its application. Otherwise, my lord, we want to create a state of anarchy where a party will choose which orders to obey, when to obey, and when to disobey. That is serious circumstance. About the criminal charges, your lordship, you notice in the purported criminal charges, the complainant is the first defendant. And we all know the great principle of criminal law, presumption of guilty, presumption of innocence. The fact that you have been charged does not make that document a forgery. The directors of the printing remains innocent until it is proved contrary. My lord, the fact that somebody has engineered a prosecution cannot be a basis for him to invade and violate the court orders. My lord, I will be asking you to enforce, to ensure that the orders are enforced until when the first defendant, who it is confirmed has disobeyed court orders. In fact, I will be asking you, my lord, to deny from now henceforth, you deny Professor Ujeda and his team any audience until they comply with the court order. It has been confirmed by this court that they are in total defiance of the court orders. They should not be heard before you until they comply with the court orders. I pray, therefore, my lord, we proceed with the business of the day. And the business of the day is to ensure, as the OCP, the county commander, why he has not complied. My lord, you see, look at the record of your sister. Look at the court record and you see a lot of mischief. When we appeared on 25th, Mr. Biko and his colleague appeared. When we were told to come back, my lord, on 27th, they chose not to appear. We were told to appear again before the judge on 30th. They chose not again to appear. Now today, when they realize that the county commander is about to execute, they conveniently appear. So they appear before you when they want and when they don't want. When you are told to go and confirm the status on the ground, again the first defendant, because he knew the status, they chose not to go to the scene. Therefore, I will be pleading, my lord, that you don't hear the first defendant until they comply and we proceed with the order of the day. The order of the day was not to hear the first defendant on the application. Let them not try to hijack the business of the court of today. My lord, I pray that we proceed with the business of the day and you ignore the submissions by the contemptor with the content those submissions deserve.
Mr. Mduli.
Your Lordship, on our part, I fully associate myself the sentiments of my learned senior Professor Ujeda. Your Lordship, as to the issue that has brought us before court today about the county commander obeying court orders, First of which the court note that the county commander is not a party in this suit. And I have been called today to explain the procedures and processes that have to be followed before police enforce a court order. Further, Your Lordship, no application has been filed before court for contempt against the county commander. If such has been done, then it has not been served either on him or on us as the office of the Attorney General. So, Your Lordship, if you allow, you can give the county commander an opportunity, just a minute or two, to say why he has been unable to implement the order as is. That is the order of 30th of January 2024.
Professor Jena, do you want to say something?
My Lord, yes, my Lord, the truth is, my Lord, Mr. Karanja, I know, is first of all conflicted. Mr. Karanja is the lawyer for Nakuru County. That's number one. He's conflicted, he knows that, he should not be here. But number two, my Lord, number two, the first defendant respondent, that is the county, is not in contempt of any order. The first defendant is charged with the role of running health as a devolved service under Schedule 4 of the Constitution. And that includes, my Lord, running War Memorial Hospital. The first defendant, my Lord, through the CC Health, Dr. Moura, therefore have a primary duty to ensure that all the residents of Nakuru County have access to health. In that regard, my Lord, the first defendant took charge of Nakuru War Memorial Hospital. This body, my Lord, that Mr. Karanja is representing, the group of doctors who are purporting to discharge the role of the county, assumed that role in violation of the Constitution. Those are issues we will argue when we are allowed to submit on our application for setting aside. My Lord, when this court made an order in the first instance, this court was not apprised of the actual state of the titles to the land in question and of the role of the county in the transition. This court was not apprised, my Lord, of the fact that the land in question now belongs to the county. So there was a misrepresentation of facts, my Lord, because this court was not told that the documents that were submitted to court and that were given to court and that informed the orders issued by the court were outcomes of a failure. And that is the truth. Mr. Karanja knows that. My Lord, if that is the case, my Lord, why would the court be compelling the county commander to enforce an order that goes against public policy and that was obtained without disclosure? My Lord, the prudent thing to allow parties to come before you, argue all the issues, because no party is in contempt. The county government simply took over its role of we have not appointed court. We did not appoint the visit, my Lord, because when this matter was mentioned, we were in Nairobi and the inspection by the registrar was supposed to happen in 1 hour. It is not possible, my Lord, my advocate to leave Nairobi and in Nakuru in 1 hour. It is humanly impossible. And that is why we sought to leave, or we sought not to be present during the visit, my Lord. My Lord, this matter is a matter which will be determined, my Lord, if the court determines all questions before it. And all questions, my Lord, will involve hearing all parties and taking into account all the submissions by parties. My Lord, before then, compelling the county commissioner to remove the from executing its constitutional role would be 200 people on which this court is built. That is to deliver or render justice to the people of this country and to the people of Nakuru County. That's all.
Your Honor, if I may, just a brief rebuttal. In brief rebuttal.
He made a opening statement. You replied. Yes, replied.
Yeah.
So you have no right again to reply. You will reply to your reply. Otherwise, you will continue forever.
It's okay.
So my observation is that there is not hearing text. Let the court not go into the merits of the application of the main suit. The reason of the court today is to hear the county commander as to why he has not complied with the court order made on the 30th January 2024. All questions should be determined after hearing all the parties. So today, the day for the county commander. And we will allow him to explain under what. So the county commander will explain.
Your question? I swear before the Almighty God and before the statute that what I'm about to say is the truth and nothing but the truth. So help me God.
Okay, you are the first court explain that was issued to you. What's your explanation?
My Lord, my name is Ndanyi, the County Police Commander for Nakuru County. I've been away and I just reported on it today. The reason for explained by the State Council. As he has rightly put it, there are procedures to effect a court order. When a court order is related to lower cadre, an example of an OCS or OSPD, then those court orders are submitted to Sub-County Security Committee. They are discussed, the deliberations, the limits are taken, and thereafter they are forwarded to the County Security Committee. We deliberate, that the County Security Committee is where I sit. We deliberate on the same, after which again the limits are taken and again we forward the same to the regional security committee. So it goes like that at the national level. So for my case, now that it was up to me, now we are supposed to, the county security committee is supposed to sit, convene a meeting, deliberate on the same. We do take the minutes, and then the deliberation of the same are taken to forward to the regional security committee. They also deliberate on the same, and then forward the same to the national. So that is how we execute the court orders as a policy.
Maybe just to add, there are guidelines that guide the County Security Committee when they are. Yes.
So let me explain.
So that is what I wish to explain, my Lord.
Your Lordship, like I was saying, there are guidelines that guide what the County Security Committee has to do before execution of a court order. And with the permission of this court, we can supply those guidelines that emanate from the National Security Committee. Given an opportunity, Your Lordship, we can supply the same for the court to see why his hands are tied, why he cannot do what is being done until that committee sits and deliberates on what he's being told to do. Without having a go-ahead from that committee, his hands are tied, Your Lordship. Just a brief submissions in relation to the same. Yes,
I've had the county commander and his explanation, and do find that court orders override the procedures of government explained by the county commander. Court orders are not negotiable. They need to be obeyed. Disobedience of court orders through government procedures signals a trend that puts the rule of law and the dignity of the courts under threat. Senior public officers must obey court orders. It is right that courts have the impelling force of the rule of law. This is a fundamental constitutional value that the government must respect in order to preserve the ever-fragile fabric of constitutional democracy. The existence of the government is only guaranteed when the citizens respect the rule of law. When the government fails to observe the lowly in the society will also fail to observe the law, and this will lead to anarchy. I do direct the county commander to comply with the court order before midday today, failure of which will be cited for contempt. We need to deal with this matter once and for all.
Madam, with your permission.
Yes.
Madam, with your kind permission.
Yes, Professor Agenda.
Yes, Madam, the new date for the hearing of applications dated 2nd November and 6th November, we have complied with the directions previously issued by the court.
Madam, I will be opposing to them being declared a date for that application. They are in contempt. I have an application for contempt. Any. That should be given priority. But before that, my lord, going by the orders you have given for compliance, I will pray that you mention this matter today at 2:30 to confirm there is compliance, and then we take further directions on the pending applications.
I will give you a mention date on the 5th of February 2024 at 10 a.m.
5th of February.
5th of February at 10 a.m.
5th Fifth most all right. Mr. Ndanyi, relax now. This is not a life and death. You're in charge.
Advising your client to comply and all will be well.
Okay. Next matter. Mr. Apando, you are ready?
Your Lordship, I am ready. I also see my colleagues in court.
And the state?
My witnesses present. But for honor, I appear to the plaintiff in the matter.
My name is Kamau Chomba. I represent the plaintiff. As the court has directed, the county command out to comply with the court orders by 12. We are going to the ground and hope that the same will be complied with. So join us. We hope things will go as we have requested the court and the court has ordered. So he was in court. He was in court. We thank him for that. He mentioned on those are things that are for the court. So I'm not going to details of the matter. We will cite him for contempt because the court orders have to be and must be complied with. Otherwise, we will be facing anarchy in this country.
Kindly brief us, by the time this matter was being mentioned, was there compliance with the orders?
They have not complied with the court orders. That is why we are here today. That is why we are here.
You can tell us maybe among the cases for
that is something discretionary upon the court. It can run from 1 month, 6 months. It depends with the court. It's discretionary. That is all. You can join us at the ground.